Welcome to those of you that have joined us. We have just opened the link, so we're just waiting for a few minutes to allow everybody to join before we start. Welcome to those of you that have joined. We have just opened the live link, so we're just waiting for a few minutes to allow everybody to join before we start. Welcome to the 5 Stone Buildings webinar program. We have just opened the live link, so we're just waiting for a few minutes to allow everybody to join before we start. Whilst we are waiting for everybody to join, I should just remind you of the house rules. So just to let you know that this webinar is being recorded. If you have any questions throughout this webinar, please put your questions into the Q&A box and our speaker will try to come to your questions at the end if we have time. If you do not wish to be identified when asking your question, then please tick the anonymous box so that our speaker will not identify you in their response. And I will now hand over to Arabella.
Good afternoon, everyone. I'm Arabella and I'm the new tenant at 5 Stone Buildings. I do have some slides for you today and I think they will be shared afterwards. I think Joe will kindly send them out or make them available. Today, I'll be doing a general, concise overview to contracts to leave property by will in half an hour. The reason why I wanted to speak on this topic is that I think it's not uncommon to find that people throw in, oh, the deceased promised to leave me this in a claim, even where they're not pleading a proprietary estoppel claim. They'll often throw in this alleged promise for good measure. And I think it's good to have a sense of the point at which that promise might become a problem for you if you're defending the claim. Obviously, the fact of a promise might have some knock-on consequences in the claim. If it's, say, a 1975 Act claim, it might go to whether the deceased assumed responsibility for an applicant or whatever it is. But I'm talking more about when you might have a legal problem and when the promise might give the other side a claim in its own right. And I think it's important to have a feel for when that might be a problem and when you don't have to worry so much and you can bat it away. And on the flip side, you might be for the potential claimant and have a client come to you and say, I was promised this and didn't get it. What are my options? So the first real question is whether a contract to leave property by will is enforceable. Thank you, Joe. Yes, it can be valid and enforceable, and in the right circumstances, it can lead to various remedies. And as well as a promise to leave property by will, you can also have a valid agreement not to revoke an existing will. An obvious example of that is a mutual will. But I'm not actually going to focus on mutual wills today, as that's a whole other area. I'm just going to look generally at testamentary contracts. So the idea that you can have a valid contract to leave property by will is a bit confusing because it seems to conflict with our ideas of testamentary freedom. In this jurisdiction, the usual position of a will is that it is a document which has no effect until the testator's death. And generally, despite having executed a will, a testator remains free to deal with his property as he wishes during his lifetime, and he can go on to revoke that will that he has executed. But to a certain extent, testamentary contracts don't actually conflict with the principle that a will is an inherently revocable document, because the promisee's rights won't arise under the will, but contractually. Separately to his will, a testator can bind himself personally and bind his assets so that his personal representatives after death have to give effect to the agreement, and that may end up being at the expense of his will beneficiaries or his intestacy beneficiaries. It's basically like a testator who leaves his whole estate to his beneficiaries under his will, but ends up dying with huge debts, so that the practical effect is that despite the will, the beneficiaries end up with nothing. So the thing to bear in mind is that the rights of the promisee exist independently of the will. If we could move to the next slide, please, Jo. Turning now to the principles for a valid contract to leave property in this way. Bearing in mind what I've just said, you won't be surprised to learn that contract law principles apply. The reading I've done on this bears out 4 key principles to remember. Firstly, there has got to be an intention to create legal relations. It has to be more than an informal family arrangement. The fact that a testator has made a statement about his testamentary intentions, as many people do, is not necessarily going to be sufficient. There must be a positive undertaking. It's got to be more than just a representation that the testator intends to do something in the future. The question of whether the testator's words have created a binding legal obligation on him will largely depend on the language that the parties have used and the surrounding circumstances. And a court would be very likely to look at the degree of formality that was involved. Because, as you'll well know, lots can be said within a family about testamentary arrangements, and some testators seem to quite enjoy talking about it. Obviously, the law isn't necessarily going to hold them to each thing they say in a domestic context. Also, one thing to flag on this principle, in these sorts of situations with an elderly testator, you'll probably also be bearing in mind issues of their capacity when it comes to things that they've apparently said and promises they've allegedly made. The second key principle is a requirement that I think probably sweeps away many potential claims, because it's that the promise must either be supported by valuable consideration or made by deed. There may well be situations where there was consideration for the promise, whether it was providing care for the testator or something else, but in many cases, I think that family members in particular are unlikely to immediately think of consideration when they enter into these sorts of promises, because a common view is that you don't necessarily have to do anything for your inheritance. You just get it by virtue of your relationship to the testator. And then as for deeds, I also can't think of many typical family circumstances in which people would opt for a deed, because if you seriously think that you're entering into a valid agreement for property to be left by will, there's not much point just formalizing the fact of agreement. What you expect is that the testator will just do it and put it in his will, as opposed to not doing it, but signing a deed to reflect the agreement. But we will come on to look at a case where there was valuable consideration in a family context, so it can certainly happen. Third, the terms of the contract must be sufficiently certain. A whole range of promises can be valid. It might be a promise to leave specific property, like the testator's house, or to leave a pecuniary legacy, or a specific share of the residuary estate, or all of the residuary estate. But an example of a promise that the court felt was too vague to be unenforceable was a promise to make ample provision. So it has to be clear what the subject matter of the contract was. And then fourth, if the promise relates to land, that falls within Section 2 of the Law of Property Miscellaneous Provisions Act 1989. So the contract, if it's to do with land, must comply with that section, and it will be void if it's not in writing and signed by each of the parties. If you have an alleged contract to leave land by will that was made before the 27th of September 1989, it will be subject to Section 40 of the Law of Property Act 1925 instead. And in the absence of a written contract, it might be possible to apply the doctrine of part performance. But given that we're now in 2021, the chances of having lots of pre-1989 testamentary contracts are getting ever more remote. So the general thing to remember is that if land is involved, it has to be in writing, signed by both parties. So if all of these requirements are fulfilled and a valid contract is made, what's the position then? What duties are imposed on the promisor? Could we go on to the next slide, please, Jo? It's clear that the promisor's personal representatives will have to give effect to the agreement after his death, but you might also wonder to what extent the post-contract promisor is free to deal with his own assets in his lifetime. The answer is that it depends on the precise nature of the promise that was made. And this is where it can get very fact-heavy and a bit confusing. Where the promise is to leave a specific property by will, the promisor will repudiate the contract if he disposes of that property during his lifetime. But where the promise is to leave a share of a residuary estate or all of it, the promisor is at liberty to use any or all of his property for his own benefit in his lifetime, or even to give it away prior to death. And when you think about it, that makes sense. The agreement was just for a share of his residuary estate, whatever that might look like. There was no agreement about how much might be in it. But even in that scenario, the promisor definitely doesn't have total freedom, because he can't defeat the promise by making a testamentary disposition that's inconsistent with it. So it would be a breach of contract for him to go on to leave his residuary estate entirely to someone else, and his personal representatives would have to give effect to the contract in that situation. A promisor in that situation also can't try to be clever and do something like settling all his property on himself for life with remainders over to various other people, because that's making an inter vivos disposition, which is essentially, well, it essentially has the same effect as a testamentary disposition, so that won't be allowed either. When it comes to a contract to leave a specific pecuniary legacy, the construction of the contract becomes important. It might just oblige the promisor to make a will which contains the pecuniary legacy agreed, and in that case, the promisee is no different to any other beneficiary under the will, and like all those other beneficiaries, they'll take the risk that the promisor's estate might turn out to be insolvent or insufficient to satisfy the gift, so that the promisee gets a reduced sum or nothing at all. Alternatively, the contract could be construed as imposing an obligation on the promisor to make the gift effective, and in that case, there will be a breach of contract if the promisor's estate is insolvent or insufficient. Next slide, please, Jo. Finally, if we're thinking about general promises not to revoke an existing will, that's arguably even more unusual, and you might well think it's getting difficult to square that with the idea of testamentary freedom. But a valid promise not to revoke is treated as being confined to prohibiting acts of intentional revocation by the promisor. So things like destruction of the will or executing another will or codicil. What the prohibition does not encompass is automatic revocation of a will by operation of the law. So if that happens, there's no breach. That will include things like automatic revocation of the will upon the marriage of the promisor, which is a factual pattern which continues to be relevant today. So it's good to know. For example, even if ex-husband can prove that during their marriage, ex-wife entered into a valid agreement not to revoke her will, she won't have breached that agreement by divorcing, remarrying, then dying and allowing the intestacy rules to dictate the devolution of her estate. If it was a very formal arrangement and the contract, that was a written contract and it was drafted so as to purport to prohibit revocation through the marriage of the promisor, that contract will actually be void on grounds of public policy for obvious reasons, unless that offending term is severable. I think there's actually a case on this called Robinson and Omanet from 1883, which is authority for that proposition. But you have to remember that this whole marriage exception thing is only really relevant to promises not to revoke a will. So if you promise to leave property by will and then get married so that your will is automatically revoked, that might, in some circumstances, be a breach. Moving on to what remedies are available for breach. Could we go to the next slide, please, Jo? Again, the remedies depend on the nature of the promise that was made. As a general rule, if the promisor has breached his promise, the promisee is entitled to recover damages from the promisor's estate. In some circumstances, a claim for specific enforcement might also work, and the court might order the promisor's personal representatives to transfer the specific property to the promisee if it's been left to someone else by will in breach. It might also be possible to specifically enforce a contract to leave a share or all of the promisor's residuary estate, but this will unsurprisingly be enforced subject to the payment of funeral and testamentary expenses and debts of the promisor who's died. If the contract relates to a specific property and the promisor breaches it in his lifetime, so instead of leaving it to someone else in his will, he tries to sell it to someone else in his lifetime so that he obviously can't leave it by will now, a promisee can sue for damages at once, but the damages are likely to be subject to a reduction for the acceleration of the benefit, and depending on the construction of the contract, they could also be reduced for the contingency that the promisee might have failed to survive the promisor, which would have meant that the gift would have been subject to lapse. And if in one of these situations, the promisee can intervene before a purchaser for value without notice acquires the property, he should be able to get a declaration of his right to have the property left to him by will and an injunction to restrain the testator from disposing of it in any other way. But obviously the promisee would have to be very in the loop with what the testator was doing to get there in time for that. Where the promise is to not revoke a will, the promisee can't prevent the promisor from revoking his will by bringing a claim for specific performance or an injunction. All he can do is recover damages from the promisor, or if the promisor has died, from his estate. So I think that's how we square it with the idea that a will by nature is a revocable document. The promisor is never prevented in any way from revoking his will. He can do it. There are just financial consequences to him doing it. Next, I wanted to touch on third parties to one of these contracts. Could we have the next slide, please, Jo? Thank you. The basic principle is that where a contract is made on or after the 11th of May 2000, the Contracts Rights of Third Parties Act 1999 applies. This means that a person who isn't a party to the contract, but who stands to benefit under it, may be able to enforce it. Under Section 1(5) of that Act, in the face of a breach, such a third party could be entitled to any remedy that would be available to him had he been a party to the contract. And the third party doesn't even need to have been in existence when the contract was made, but he does have to be identified by the contract as either a member of a class or by his name or by a particular description. You might be thinking at this point that this sounds particularly niche, but it's not difficult to imagine scenarios in which a parent might be negotiating an agreement about leaving property to their offspring. And there happens to be a case in which this happened. I should say that there are a fair number of cases in this area, And from what I can see, the vast majority of them are from the 1800s and the early 1900s. Many of them are about promises to leave property by will, where the consideration is having to marry the promiser's daughter or something similar. But there's a relatively recent case from 2006 called Irani and Irani, which is very readable, quite short. And I thought it would be useful for us to take a look at it. And as I've said, it involves third parties. I should point out that the contract in Irani predated the Contracts, Rights of Third Parties Act, but as you'll see, it wasn't actually necessary to enforce the contract under that act in any event. So could we have the next slide, please, Jo? So Irani and Irani, it's not a particularly complicated fact pattern, but there are a fair few children involved. So I thought this family tree drawn by my fair hand would be useful. The husband and wife were married and had 3 children back in the 1950s and 60s. And they also seemed at some point to acquire an informally adopted child who seemed to be treated like one of their own. But husband was unfaithful during the marriage and in the 70s had a child with another lady, that's child E. Wife was a bit fed up by this point and got a divorce from her husband. The divorce was granted in the 80s, and then wife, well, now ex-wife, issued an application against her ex-husband for ancillary relief. Both parties had solicitors involved at this point, so it was quite a formal situation, which turned out to be important. After the application for ancillary relief was issued, ex-wife spoke to ex-husband over the phone, and he said to her, "Why are you shaming me with this claim?" And she said, "The only thing that will persuade me to give it up is if you put this house in the names of children A, B, C, and D." And it seems that ex-husband agreed to this, and his solicitors wrote to ex-wife's solicitors with an offer compromising the ancillary relief claim on the basis that he would leave the property to children A to D in his will. There was no written record of ex-wife accepting the offer or both parties signing a compromise agreement, but ex-wife said that she did instruct her solicitors to accept the offer. And in the circumstances, ex-wife did not pursue her claim for ancillary relief, and ex-husband soon after wrote a document, a bit like a kind of declaration or letter, saying, "To whom it may concern, in accordance with my divorce settlement, I leave this house in equal shares to child A, B, C, and D," and he signed it. That obviously wasn't a valid will, even though ex-husband clearly thought it was. So when he died in 1996, he died intestate. And when he died, his only real asset was that house. Could we go on to the next slide, please, Jo? Please enjoy the very sophisticated infographic I made so that you could visualize the case. Child E first started intimating a claim in 1999. And after a bit of a non-starter, he eventually issued properly in 2005 and claimed that as the deceased had died intestate and he was a child, under the intestacy rules, he was entitled to a share of the property. Wife was obviously a defendant to this claim, along with the other children. And in response to child E's claim, and as part of the same proceedings, wife made a third-party claim naming her children as defendants, in which she claimed that she had orally accepted the terms proposed in the compromise offer letter from ex-husband, so that there had been a contract between them concerning the property, and this meant that the only real asset in the estate was not available to devolve under the intestacy rules and belonged to children A to D. The consideration for the contract was obviously wife refraining from pressing her ancillary relief application. So the judge hearing this claim had the benefit of some contemporary correspondence and some documentation, and then oral evidence from ex-wife and 3 of the children, and a witness statement from child E that he didn't seem to be particularly impressed with. Neither side called the solicitors who'd been acting for the parties at the time, And the judge seemed to be surprised by this. It's not really clear why they weren't called, but as the events were 20 years before, possibly they had no useful memory of it. It's clear that the judge thought that the wife and her children were truthful witnesses, and he felt able to draw the conclusion that the wife's solicitor had accepted the offer and had concluded a contract. And he reached this conclusion on the basis of a number of reasons, one being the presumption that a solicitor with instructions will carry out her duty. And then also the fact that the deceased had gone on to execute what he thought was a valid will in the form agreed, referring to the divorce agreement. And then ex-wife had obviously discontinued the ancillary relief proceedings. The judge was clear that it didn't matter that ex-husband's will was invalid, the rights arose under the contract. If you're particularly sharp, you might be thinking, but this was a contract about land. Where's the written agreement signed by both parties? Because of the date of the contract, back in the 80s, I think mid-80s, it was Section 40 of the Law of Property Act 1925 that was the relevant provision, not Section 2 LPMPA. And the judge referred to a case from 1975 called Tiverton Estates and Warewell, and said that it was quite clear as a matter of law that if an offer is made in writing and accepted orally, that contract is in law a contract in writing, and so is enforceable. I wonder if there was an element of the judge taking to wife and children A to D and not being very impressed with child E and really striving to find a solution to help. But it's a case that, because of the particular fact pattern, the relative formality of the agreement, because the parties had divorced by that stage, the consideration that was clearly given, the clarity about the subject matter of the contract, it actually proved enforceable. And there was no need to think about enforceability and third parties, because the wife was around and was on her children's side to enforce it for them. So in the last few minutes, there are just some final points that I hope will be relevant to practitioners in this area. Could we have the next slide, please, Jo? First, I think it's really important to emphasize that a will that's made in breach of one of these contracts will remain a valid will. Probate of that will can be granted, and it's unlikely that the probate registry will be very concerned by the contract. Any redress will come in the administration of the estate, and the property that is subject of a valid contract will be held by the personal representatives for the benefit of the promisee. My second point relates to claims under the 1975 Act. Just to flag this up, the Act itself provides at Section 11 that for the purposes of the legislation, the deceased's net estate can be deemed to include property which is the subject of a contract relating to a will, no matter how long before the death of the deceased the contract was made. The powers of the court here are discretionary, and obviously the purpose of Section 11 is to defeat transactions that were intended to prevent a future 1975 Act claim. The court is probably unlikely to upset the contract unless it's satisfied that the contract was made with the intention of defeating a 75 Act claim, and that the promisee didn't give full valuable consideration, and that in exercising its powers, the court would be facilitating the making of financial provision for the applicant. And the court will obviously be looking at all of the circumstances of the contract and things like the relationship of the promisee to the deceased, the conduct and financial resources of the promisee, and anything else that might be relevant. So finally, I think in answer to the questions I raised at the start of this talk about when promises to leave property by will become a threat to a defendant in terms of being a cause of action in their own right, I think it's fair to say that it's only in quite specific circumstances. There are quite a few requirements and possible outcomes, and in most cases, a claim alleging breach of such a contract is unlikely to be that straightforward, often because the parties may well have contracted in a relatively informal family setting. obviously there might well be quite a bit of crossover between a potential claim based on a contract to leave property by will and other claims that might be available. And a potential claimant might well consider whether it would just be easier to bring a claim based on the 1975 Act or proprietary estoppel, or even something like the law of constructive trust. So that was all I really wanted to say in this introduction to the topic. I think there's one question